Good evening and welcome to the second session in Basics of Writing. Today we have with us research scholar Ms. Meenakshi Nagamanickam from IIT Kharagpur. Ms. Meenakshi is a legal research enthusiast who did her BA LLB from Symbiosis, Hyderabad. She has always been keen on working in the field of intellectual property law and has interned under various IP law firms such as Rights and Marks, Cholamandal IP, and Origin IP. Currently, she is pursuing a 2-year LLM at Rajiv Gandhi School of Intellectual Property and is working on the project Geographical Indications and Plan B registration in India. Ma'am, I would now like to invite you to take the stage.
Good morning. Good morning to all the participants present here, and thank you for such a wonderful introduction. So let me begin by continuing with yesterday's lecture. I guess Ms. Bhavya has taken few classes on the basics of writing, and apparently she stopped with the abstract, how a person is supposed to go with the abstract. So I'll be beginning with how to write an abstract. Just a second, I'll share my screen. I hope the slides are visible to everyone.
Yes, ma'am.
Okay, thank you. Yeah, so how to attract a reader to read the entire paper? It's very difficult for anyone to read the entire paper. So that is why we write an abstract. Basically, it is a summary of your entire paper. So what a person is supposed to include in an abstract writing, that we will look into. Firstly, abstract comes in the beginning of the paper. The beginning of the paper starts with an abstract. So usually what research scholars do, given thesis or dissertation submission, or even article writing for that matter, we write abstract at the end. Once the entire research is over, we write the abstract at the end. But in cases of submission to any conference or call for papers as such, we are supposed to submit the abstract in the beginning itself, and we are given a specific deadline to do so. So in such cases, what a person is supposed to do? So before getting into how to write an abstract, let's see there are two types of abstracts. One is descriptive and the other is informative. So in informative, it's only purpose, objective, and method. Results and conclusion of your paper are not usually included in this. Whereas in descriptive, all the following are included. That is, you will mention what is the importance and purpose of your paper, what are the objectives, and what are the methods that you use to conduct the research of your paper. Then what did you find, what are the results, and then the conclusion. So let's understand this with the help of an example. Here in this abstract, we can see that the first 5 lines, the author has introduced the subject matter, that is about COVID-19 and how it has taken a negative toll on mental health. So this is how you begin writing an abstract. You give the importance of your study. The topic of your study is introduced in the first 2 to 3 lines. Then comes the objective. Why are you writing this paper? What is the aim? What are the objectives of your paper? As we can see here, the author has given the prospective study aim to assess the impact of COVID-19 outbreak on mental health and to investigate the ability of pre-outbreak. So, and so on and so forth. So the author is trying to put forth what are the aims of the particular study. Then it is followed by methods. I'm sure that you people have gone through the research methodologies, but here in an abstract, you're not supposed to give examples or explain in detail what are the primary sources, secondary sources, or the types of methodologies. It should be very short in 1 or 2 lines. What are the methods that you used? Then comes the results and then conclusion. Now comes the question, in case the results and conclusion usually we derive at the end of the research, but in case we're supposed to submit the abstract to some research conference or something, we have to submit the abstract. In such cases, obviously we will not get any result, so we can omit the result, and instead we can add on to what will be the prospective result, not necessarily the exact result. And once your abstract gets selected, accordingly you can change your results. I mean, you can change your abstract when you're submitting your final paper. And after the results comes the conclusion as well. So even everything should be crisp and short. We shouldn't explain in depth. Also here, I would like to tell you one thing over here, that we shouldn't introduce the topic in detail. Like I would like to give an example here. One of my friends, he's writing a research paper on blockchain and NFT, metaverse, all of that, and its correlation with intellectual property rights. So what he thought was, in an abstract, he started introducing the topic itself. The first paragraph, his entire 6 to 7 sentences was only about what metaverse is, what blockchain is. That is not how you're supposed to write. That is not how you're supposed to start an abstract. That is the job of introduction. Your paper, in your paper, after the abstract is over, you will start with an introduction. So that introduction will comprise of all the details of your study. Like, you introduce the topics. So you should never ever start your abstract the entire 6 to 7 lines. It shouldn't consist of your introduction. It should be very short. It should just tell the importance and why the importance and the topic in just 2 to 3 lines. So next, always try to use terms such as this paper, the author, and so on. So for example, this paper this paper aims at, this paper uh, this paper proposes to, this paper aims at, or this paper, in this paper the author has attempted to. So these are some of the examples how you can begin, how you can include these sentences, like how you can frame sentences while writing an abstract. So next, usually the research papers, wherever you're submitting to, the universities, they'll give a particular word limit, guidelines. In the guidelines, they'll be clearly mentioning it, but usually it varies from 150 to 300. So around 250 words is a really good abstract. Next, what are the keywords? So once your abstract is done, the very next sentence, the very next line will be keywords. To 7 keywords. That is not how an abstract should follow. I mean, the keyword should limit, it should be limited to 3 to 5 words. 4 to 5 is really good. Yeah. So this was the summary of how to, I mean, I summed up everything what Bhavya couldn't cover yesterday. So any doubts, I will answer. I'll pause for 2 minutes so that we can discuss about abstract if there are any doubts. So no doubts. Should I continue with the topic? Okay, let's go ahead. Is my PPT visible?
Yes. Yes, ma'am.
Okay, thank you. So in today's class, we will be looking into how to read a judgment and how to write a case commentary. So as far as my knowledge goes, I don't think so most of you are from legal background. So I will keep it very simple. I will teach you from the scratch. So need not worry, and let's get going. So I have designed in such a way that first we will see how a judgment is. We will try to deconstruct it. Like we will make it simple. We will make the entire judgment very simple. And then we will try to reconstruct again, and we will see how a case commentary is written. So in order to read the judgment, I will take you to SEC Online, and we will navigate throughout SEC Online, and we'll see how a person can easily use this legal database. Yeah. So as we all can see here, there is word search, find case law by section, by citation, by party name, topic, words and phrases. So first and the most simplest thing, like how we directly type in Google, that is what a word search does here. So click on word search. For instance, let's take the case of narco analysis, that is Selvi versus state of Karnataka. And usually all this pops up. It basically does the work of Google, but with respect to law, case laws. Yeah. As you all can see here, you will get the results like this: digest notes, judgments, everything, so on and so forth. Here, SEC Online is not only comprising of case laws, it has articles related to the particular topic, everything, reports, notifications, everything. And in case you want to look into the articles alone, so you can just go here and click on only, and see only the articles will appear. And in case you want to go back, just reset. So now let's look into the case law, that is Selvi versus state of Karnataka, that is here. So once I click on this, here the judgment appears. And the simplest way to navigate through an entire judgment is to find in within judgment, like how we usually do control F for every Word document or any internet site. Similarly, here also you can do a word search. So let's look into this 5-10 minutes later. Before this, I will show you, I will navigate through SEC Online, the other important sections of SEC Online. So we just went through word search. Now let's find a case law by section, a given section. So here, as we all can see, here you have to type any term of an act. For instance, there is Criminal Procedure Code, or Copyright Act, or Geographical Indications Act, or Indian Penal Code. So like that. Let's look into Indian Penal Code. One interesting thing that I found here was it isn't termed as Indian Penal Code, and it is just termed as Penal Code. So one should keep in mind to use this legal database very often so that you will get to know what and how it works. So let's go here to Penal Code and click on Find. You will find all the sections. So basically the entire Bare Act is given. And now you can again press Control F, and let's go for defamation. So here you can click on the section and click on Go. So you can see similarly, whatever you want after this, you can click on only and then reset and do accordingly. You will have all the material available. Let's see the other one, the next one, that is by citation. Now, let's understand what a citation is. As you all can see here, Supreme Court cases, SCC full form Supreme Court cases, and 2005 is the year, and 1 is for the volume, that is the first one. Next to the year is the volume, and after SCC, next to SCC, the numbering given is the page. That is 2005, 1 volume, SCC, page number 1. This is how it works for the rest of the things as well. So let's take a citation and look into it. So just a second. So here, as you all can see, list of cases appear. Let's click on any of them and just here. According to the citation, we will get the name of the case and all the details of the case. The entire case law will be available here. So this is how you search by citation. Next is so as you can see here, you can either type, you can select the court here, like Supreme Court, depending on it, and you can just type the keywords and directly find the, like by party name, you can search, you can just type any party name, Union of India or anything as such over here and search. Similarly, here as well, this is by party name. The first one is search by party name and the second one is search by famous case names. Like I can type here the name of the case directly and I'll get a list. And here in the first one, I have to type the party name. Let's say we just saw Selvi, or the other party was State of Karnataka. So I have to type here the party's name, and here I can just type the name of the case. For instance, Keshav Nanda Bharti case, and I will click on find case and I will find the case. Next is by topic. Here again, let's say okay. And here you will find all the topics within intellectual property. So then if you click on it, let's take copyright. Okay, just a second. Yeah. And here in copyright, there are only digest notes and you can find all the material. So we saw how to do a word search, which is just like Google. Then by section, a particular act and a section, we could find the case law. Then I just said how to find by a given citation. That is the name, then the year, then the volume, then the name of the report, let's say All India report or Supreme Court. Then the party name, then just now we saw by topic. Words and phrases are a bit tricky to use. So it is on a next level. So instead of using words and phrases, you can directly go to word search and put it over here. It makes it easy. Next, then all these are just topics which are cumulatively available separately. Here you will find these here itself in the first topic, but here they are provided, they are curated and they're provided under each topic separately. You need here, you have to go and type and find it. Here it will already be readily available, but here the only disadvantage is only few topics are available. So it's better to go and do our search. So this is it. This is how you navigate through the Supreme Court case SCC online legal database. This is just a gist of it. Once we keep doing it on at least twice a week, we'll get used to it and then it will be easy. And there are other legal databases such as Manupatra, Heen Online, and LexisNexis. So a few are now, even initially they were only Indian cases, but now even SEC Online has foreign judgments as well. Like Westlaw, LexisNexis have already foreign judgments since the very beginning. Even nowadays, even SEC Online and Manupatra also, they also have foreign judgments. So this is how you navigate through. And now let's see how to read a judgment. So the first one we saw how to navigate. Now we will take, we just downloaded Selvi versus State of Karnataka, the narco analysis judgment. Let's see how to go through the judgment, and then we will deconstruct it, and then we will reconstruct it. That is, we will go through how to do a case commentary on it. Yeah. So as we all can see here, first here is given the citation of the case, and these are the judges. And here J and 3 means 3 judges bench. And here they have given Selvi and others, that they are the appellants, and State of Karnataka, the respondent, they are the parties to the case. One superior premium quality of SEC Online is they give you head notes. They separately do the analysis of the judgment given, and this is not how a judgment looks when it comes out. They do head notes, they separate it from the entire judgment and give us a crux of it. They have divided into, they've kept it alphabetical order. For instance, first they talk about the criminal trial, investigation, narco analysis as such. And here you can see the important sections, articles related to this topic, that is criminal trial, investigation, narco analysis, and all of it. And what are the important articles and sections with respect to it. And then if you go down, navigate, you will find the important paragraphs as well. So what if you click on it, it will directly take you to that particular paragraph. So this is one of the good features. Similarly, as we can see, if you scroll, the important case laws related to that particular topic, they've divided the entire judgment topic wise. Next, again, they are part B is about Constitution of India. And here, all the important articles and sections of Criminal Procedure Code with respect to right against self-imprisonment, and here what was held in the given case also is given under the topic as well, as we can see here. And similarly, the important paragraphs, as in all these excerpts from where they have taken this. If you click on para 1 or 2, it will directly take you to para 1 or 2, and it will show you this entire paragraph over there. So basically, they have given a summary of the same. And like that, so on and so forth, it keeps going on and on and on. So once this is done, I will show you where the actual case begins. So the actual case begins here. That is after the chronological list of the case laws. Here, the judgment of the court was delivered by. This is the first statement, first sentence. It begins from here. So usually, most of them don't have access to legal databases. And what they do, they just Google it. And the very first website that appears once you Google, the first website that appears is Indian Qanun. And in Indian Qanun, you will not find all these, the ones that we just saw. It is not segregated the way it is segregated here. So definitely you can use that as well, but here if you use it, will make the work very simple. It will simplify for you.
Let me paint your nails too. Which color would you prefer? दो ही है मेरे पास. ये दोनों. हाँ एक ही.
Okay, let me continue. So, yeah, just a second. Yeah. Now let's navigate and find out the important parts of the judgment that we have to deconstruct. First, we have to find where are the facts of the case. So usually in any given case, facts are discussed. And the facts, you will definitely find the facts in the very beginning itself. So you have to just skim. The main point to remember here is to skim through. You cannot sit and read thousands of pages in a given judgment. It is impossible to sit and read each and every line. And that's the reason you have to develop the skill of skimming through. Right? So let's skim through and let's figure out where can we find as you can see, I'm skimming through and I'm not able to figure it out, right? So whenever you can't figure out a particular thing that you want to right away, just hold on to that, just keep it aside, go to the next one. Don't waste your time in just sticking to one particular thing. First, you definitely have to know the facts, then the issues, then what were the arguments, and then what was the judgment given. So now, as we couldn't find out the facts where they were when we were skimming through, now let's find out by Control F and just type facts. So here, as we can see, we are not getting the facts of the case as such. We are just getting facts wherein facts of the cases that are discussed within the case. So let's leave this as well. This is also not working. So let's keep facts totally aside and let's go to the next one, that is issues. We'll come back to facts and we'll figure out how to find facts. Before that, let's not waste time and get into issues. So similarly, let's find out by Control F, let's find by typing issues. So as we can see again, there are so many issues here, right? But contentious issues in the present case, there's a separate heading given. Usually in most of the important cases under this, in given this legal data, that is SEC online, you can clearly figure out from where the actual issues begin. They have segregated it for us. That is whether, and usually the issue starts with the term whether. And here they have discussed the issues one by one. So while discussing a given issue, both the parties, here as we saw, appellants and respondents, both the parties will give their own contentions. The advocates will present their own contentions, and all of it will be discussed under a particular issue. So the first issue is whether the involuntary administration of impugn techniques, that is narco analysis, violates right against self-incrimination under this article of the Constitution. So here it is discussed clearly. Once this is over, as you can scroll, it will get over, and then again the next topic begins. Underlying rationale of right against self-incrimination, and so on and so forth. You can, if you keep scrolling, you can figure out where again here 1A, the next issue discussed, whether the investigative use of the impugn techniques creates likelihood of incrimination for the subject. So basically, this is how you skim through and you find out the issues. And while reading each issue, you can go through the contentions, and those contentions will form the base for your analysis in case commentary. And given any judgment, given any case law, the judgment is usually given at the end. The verdict is given at the end. So you have to just scroll through and go to the end of the page, and then you can see what is the, so here what have they reached to in the light of these conclusions. So when you find the term conclusion here, you can take a sigh of relief and say that from here onwards you can figure out what the verdict was. Now let's get back to facts. So since we couldn't find where the facts were by just pressing Control F, let's go and see the first few paragraphs of the case. As we found that the last paragraph, or usually the term conclusion, wherever it's there at the end of the case, there the judgment is given. Similarly, the facts of any case are discussed in the very initial pages of the judgment. That is, in the first 2 pages, or max to max in the first 3 pages of the judgment. It will never go more than that. So here. So here, as we can see, they have begun the facts in the beginning itself. Usually what happens, the first 2 to 3 paragraphs, they don't directly start from the facts. But here, as we can see here, they have begun here. That is the issue, what happened, the issue here, the present case is between who and what were the objections that were raised, and so on and so forth. So as we can clearly see, till here, till the 10th para, they have given the facts and they have summarized the issues here. We have seen the detailed description of these issues, the contentious issues here. But just a second. In the beginning of the case itself, after the facts are over, they have summarized the issues. That is here, they have summarized the issues. So let's take a quick recap of what and how to navigate through a judgment. First is usually the facts. We have to see for the facts of a particular case. And the facts are usually in the first 2 to 3 pages of any given judgment. After that, we are supposed to go through the issues. You can navigate by pressing Control F and find the contentious issues. If not, these are how. Look for the term whether. And by doing so, you can find the issues of a given judgment. Next, when they are discussing a particular issue, they will analyze that issue. So both the parties will put forth their contentions. And that is how you can analyze a given judgment. And finally, in the last paragraphs of the judgment. Also, not to forget, we have seen here pointers like what narco-analysis is, what polygraph, what brain electrical activation profile is, so on and so forth. What are the articles talking about? What are the sections talking about? Articles as in Constitution and sections here, Criminal Procedure Code. So even Evidence Act is also discussed here. So if you want to focus only on the sections and articles, you can click on that and it will navigate. And similarly, the important paragraphs are also given here. Also, as you can see here, by clicking on his name, you can actually go through and view the judgment what KG Balakrishnan has given. That is here. It will directly take you to the first paragraph. You need not, as we scrolled through the entire like all the important parts, you need not do that. You can directly click here and it will take you to the paragraph number 1 of the judgment. So this is how you cut short and you save your time in order to read huge judgments. This judgment, I guess, has let's see how many paragraphs this judgment consists of. So this judgment has approximately, around, let's say 260 paragraphs or so. So imagine 260 paragraphs. That is definitely, if you're going to read word by word and to understand the legal jargon, it will definitely take a layman, let's say minimum 3 to 4 days if you sit religiously for 4 to 5 hours per day. But instead of doing so, if you follow the tips given right now, if you just confine to facts, issues, what were the contentions and what were the judgments, or else just go to the important pointers that you want to by clicking on the paragraphs, or you just want to know a particular what has been held in a particular case, you can just click on the case and know the case. So this is how you navigate through a judgment. I will pause here for 1 to 2 minutes, and if you have any doubts, I will take them. So no doubts. Shall I continue? Okay.
Guys,
Let's
sorry to interrupt you, Meenakshi, just for a second. Guys, if you
Yes.
have doubts, then please feel free to ask, because I think the writing part and research part is a little bit crucial for the ongoing course. So if you guys have any doubts for the writing and research, feel free to ask. Because this is something that all of you are going to use in some or the other way in your future. So I think make the most of it. Thank you. Meenakshi, please continue.
Yeah, thank you, Akshay. Okay. So let's see. We have just navigated through the judgment. Now we will try to deconstruct it. I mean, we already did. How? By looking into facts. I mean, where the facts were. That is in the first few paragraphs of the judgment. Where the issues were, by navigating through Control F. And then we looked into the important paragraphs. We can just click on the paragraphs and go to the important paragraphs, and then the judgment. So once it is better to maintain an Excel sheet and then just copy paste all the material over there. Just for your basic understanding, you segregate it. That is how you deconstruct it while reading a judgment. You can open an Excel sheet and put headings as facts, issues, then the contentions from both the sides. You can segregate the parties by saying appellants, respondents, plaintiff, defendant, depending on the case, civil or criminal case. Depending on the case, you can separate them. And then any important case laws as such, and then the verdict. So you can divide this and keep it ready in an Excel sheet. This will help you to reconstruct the same in simpler language and make a beautiful case commentary out of it. So what a case commentary is basically. Case commentary, as the name itself says, you are giving your opinion, your comment on a case that has already been decided by the court. So once a case has been decided, once a judgment is out in the public, then your thought process, your comment, your reflection, your critical analysis, you will become a critique of that particular judgment. And then you will analyze the decision that has been given. In order to do so, the navigation that we did, the judgment that we segregated, that we put in the Excel sheet, now that is going to help you a lot to write a case commentary. So let's see which topic or area that you should choose and which will amount to a good case commentary that you can publish. So first of all, it is definitely better to choose an area of your interest. Like for instance, mine is intellectual property, right? So anything related to intellectual property or even disability laws to some extent, I usually go for it. But you cannot confine yourself to your area of interest. It should be something that is contemporary. Only then you can publish it. Let's say, for instance, Selvi versus State of Karnataka. This case is an age-old case. Now, if you write a case comment on a case that has been decided, let's say 5 to 10 years ago, if you open your Google and then, if you open and just Google it, saying Selvi versus State of Karnataka, you will already find n number of websites which have case comments on that particular case. So many case comments are already in the public domain. So you have to choose a contemporary topic, some ongoing issue, and then any judgment, let's say a or two back. So in that case, you can choose that judgment and go ahead. Let's say also another thing that you should remember Okay. Before going into the structure, let's remember one thing, that Supreme Court, High Court, these courts, you have to choose a case that has been decided by High Court or Supreme Court. Why not the lower courts can be a question. Because every time the parties will definitely appeal. So let's say you've started with small causes court. It will not end there. It will go to city civil court. Then it will go to the High Court. Then it will go to the Supreme Court. So usually it is recommended to either take High Court or Supreme Court. In most of the cases, law students go for Supreme Court cases. They don't even go for High Court because ultimately some or the other days they might appeal to the Supreme Court, and then again a judgment will be, a verdict will be given over there. And so it is better, it is recommended to opt for Supreme Court cases. Even I did a blunder. I chose a High Court decision, and in a week or two, the person appealed, and then the Supreme Court took on the case, and then the verdict was reversed. The High Court, the verdict of the High Court was totally reversed by the Supreme Court, and I couldn't publish the case commentary at all. I was working on it, and by the time I completed, so basically, it's recommended for you to take Supreme Court cases that have been totally decided. Here again, one must understand that even in Supreme Court, once you appeal, again there is a possibility of 2 judges bench, 3 judges bench, and so on and so forth. The number of judges who, if the number of judges increase, depending on that, the case will go on to appeal. So it's better to choose. Ultimately, I can sum up by saying that it's better to go for Supreme Court case laws. Next, let's see the structure of the case commentary. First is introduction, analysis or your comments, and conclusion. Now, let's start with introduction. So what do you do in introduction? Here, you will not introduce the case law at hand. Let's take the example of contempt case. I guess all of you for contempt. So I'm just giving an example. The case has not been, I mean, it's yet to come in Supreme Court, so it's not there. I'm just taking an example. Let's say a judgment has been given against Kunal Kamra for criminal contempt. So in such case, the introduction of your case commentary, for example, let's keep it Kunal Kamra versus Union of India, just for example purpose. So here, you are not going to introduce the facts of the case. You are going to introduce the topic of the case. That is, the topic of the case is what? The topic of the case is contempt of court. Kunal Kamra has committed contempt by publishing his video Be Like on Supreme Court using some derogatory language, and that will become the topic of your case. So you will introduce, the first paragraph of the case comment would be contempt of court, and that topic you will introduce in gist. You are not going to write what is a contempt of court, what are the types of contempt of court. No, again here, you cannot write an entire page just on introduction. Introduction should be very brief, and it should be such that a person who has no idea about the topic contempt of court, he or she, by reading that 1 or 2 paragraphs of your introduction, should get a fair idea of what contempt of court in India is. What is the current situation? What is the meaning of contempt of court in India? So this is how you begin the case commentary. Now, let's go to the second one. Second is the facts. Here, you will write the facts of the case at hand. That is, as we've taken the case of Kunal Kamra, now you will write here, Kunal Kamra tweeted on so-and-so date, and then what happened? He was tried for contempt. You will write what happened, the details of the case, the facts of the case, factual background, what happened, how it all began. But one should remember mostly what during the LLB days, what we used to do was just take, as we saw, the facts of the case are given in the first 2 to 3 pages of the judgment. We used to go to first 2 to 3 pages of the judgment and just take the facts. And given the case of SEC, usually in most of the cases, facts, the heading facts will be given. So it is very easy for a person, and the person will be tempted, definitely tempted, to just copy paste and put the heading facts and give it in a term known as plagiarism. And once you submit your case commentary, you will be checked for plagiarism, and if it exceeds the given percentage, it will be rejected. So do not get tempted to just copy paste the facts. Again, one should remember that you cannot write all the facts. Let's say the facts are distributed in 2 pages of a judgment, the first 2 pages of a judgment. You cannot write all the 2 pages of a judgment here. You should keep it very brief. You should write it in your own words. Let's say first 10 paragraphs talk about the facts of the case, but you should be good enough to brief it in 4 to 5 sentences, 4 to 5 pointers. One should remember that the facts that you're going to write in this heading, facts, whatever facts you're going to, factual background that you're going to give, it should be directly related to the case at hand. Vital facts are supposed to be taken. For instance, in the case, let's say Kunal Kamra has tweeted a particular sentence on a particular date. And here, let's say he's tweeted twice. So that is very crucial. You are supposed to say that he has tweeted, and you will definitely add that. But from that, let's say the next fact that was discussed in the judgment is not that of that importance. It is just discussing about him as a comedian or something of that sort. His other XYZ, let's say collateral thing, which is not necessary. So it is better to avoid such facts. You need to keep it very crisp in brief, and remember 4 to 5 or maximum 6 pointers. And it should be directly related to the issue. Now, what does this mean? What do you mean by directly related to the issues? As we saw while navigating through the judgment, we saw there are particular issues. Issues are nothing but the questions that courts take and they answer, so that the legal background, I mean the law that is there, it will be answered. The interpretation, they do the interpretation of a given law. For instance, let's say Article 19. Everyone knows Article 19 is basically freedom of speech and expression. Yes. Now let's take this contempt of court case at hand. Now, contempt of court, why does it happen? You are not supposed to say whatever you want about the Supreme Court. You can't just say whatever that comes to your mouth. There is a restriction, given restriction. You cannot just use freedom of speech and expression and go on talking. So in such cases, you should restrict yourself, right? So in that case, the facts will be limited. It will be directly related to the issue. The issue at hand will be whether Article 19 is absolute, whether Kunal Kamra is tried for Article 19 Clause 2, that is contempt of court, that is the restriction given. So this will be the direct issue that is related to the facts. So how to go with the issues? Now next comes the issues. Now we understood what issues are. Now let's deal how to discuss the issues. So here, as we saw, it is very, very easy for one to see where the issue is in a particular case, because in SSC Online, it will definitely begin with whether. The term whether is there. You just navigate, you will find the main issue. Again, let's take an example of Keshav Bharti. This is very famous case. In that, I've just taken one issue so that I can explain you whether the fundamental rights which are there in part 3, whether it is amendable, whether you can amend it, whether the parliament can amend it or not. So this was one of the questions that was decided in this case. So don't get confused by the terms and all of it. Basically, issue is just a question that the court is answering and making it very clear. They are making the law very clear. That is what court does by discussing issues. Now, while you discuss a particular issue, when we were navigating, we saw that their contentions, 2 parties in a case, they give their own contentions, right? So Yeah, before going into analysis part, so basically every issue should be analyzed here. This is in this analysis section, you will analyze the issues given. But before going into the analysis, in a case commentary, usually we write in a para or two. Usually we write it in a paragraph in brief what was held in the case in just one paragraph. And then we go to the analysis section. Now coming to the analysis section, here it is totally your analysis, your critical analysis, your comments. But one should keep in mind, since this is the most important part of the case commentary, all the rest of the things are anyways given in the case itself. Here we should remember that we should understand and read the arguments of the case. We should analyze what are the issues and what were the arguments that were put forth by both the parties. You cannot just copy paste. You can never ever copy paste from a judgment. You cannot take paragraphs or sentences and directly copy paste. You cannot do that. You cannot. So let's say Kunal Kamra's he is appointed an advocate, and the advocate is putting forth his contentions on behalf of Kunal Kamra. He's saying that I have under Article 19(1)(a), I have the right to freely express whatever I can. So that is one of the contentions. Let's say you cannot verbatim, that is point to point, word to word, you cannot copy. You have to write it in your own words. And how do you do that? You do that by first analyzing what was the reasoning. You can give what was the reasoning. How can you look into the reasoning? You need to read the arguments, you need to analyze it, you need to give what was the reasoning given by the court, and do you agree with the reasoning or not? Is the interpretation of law done properly or not? So here for the interpretation of law, you need not, any layman who doesn't know the law will definitely find it a bit difficult to interpret the law, to understand whether the law is correct or not, whether the law was interpreted rightly or not. In that case, what you can do, you can first read the important articles. Like for instance, in this case, important articles would be Article 19, Clause 1, Clause 2, which is very simple. You can confine yourself to the articles of a case, and as we saw in SSC Online, you can directly see what are the important sections, important articles, and accordingly try to interpret the law. It is very easy once you start getting a hang of it. It is not at all difficult. So the next part is the conclusion part. Here, you have done certain analysis, you have gone through the arguments, you have given your own reasoning, whether you agree with it, you don't agree with it, and you critically analyze the judgment, the arguments put forth, you critically analyze them. You come up with pointers such as the reasoning was not correct or something was lacking in this, something of that sort. And once you do so, you will find out the gaps, right? You will find out the main pointers, the main gaps, and what impact the judgment has created on the public at large. For this impact, let me take an example of LGBTQ community, right? There was this judgment, and wherein it decriminalized LGBTQ, right? So here, what impact the judgment did on general public at large, that will be given here. You can write what were the gaps that happened in the past, and what the judgment has, how the judgment has beautifully come up with decriminalizing it. Do you agree with it or not? So all that you will just sum it up over here. Now let's see what are the do's and don'ts, what you're supposed to do while writing a case committee. This is just a summary, so please listen carefully. First is, you have to do a swift reading of the judgment. You cannot read one by one. Thoroughly, you have to just swift through and just highlight the portions. You have to reread the judgment. That is, you have to skim through, you have to just go through the entire judgment, and you have to just highlight it. Use the highlighter option, is available over there. Any important contentions and the judgment. the conclusion, you need to highlight it. And once you highlight it, you can either highlight it or you can either put it in Excel, and then you can accordingly type in your own words the analysis. That will make your case commentary very, very simple. Next is how much is the word limit. Usually, again, if you submit your case comment to any journal, you will be provided with certain guidelines that you have to follow, and usually it ranges from 2000 to 3000 words. A good one would do around somewhere in between, that is 2500. It will be a good case commentary, and that will sum up to 8 to 10 pages, around 8 to 10 pages. So you cannot you cannot be over ambitious and write the entire judgment and sum it up. No, you have to write it to the point. You have to keep it very precise. You cannot drag, you cannot write lengthy paragraphs. You have to keep it to the point. And one of the most important things is you have to do proofreading before submitting your case commentary. And one such tool that helps you is Grammarly. It does wonders in just 2 to 3 minutes. I recently submitted my book review, and within 2 minutes, it just showed me what all the corrections I'm supposed to do, and I submitted. So it definitely helps you. And the last one is you maintain a uniform citation style for footnotes. Here you will definitely not give so many footnotes as you usually give in an article. In an article, depending on the number of case laws that you give, or depending on the terms that you want to explain, footnotes will definitely increase in an article writing. Compared to article writing, case commentary will have very minimal footnotes. So here you're supposed to use one citation style, any one, either APA, MLA, or let's say Chicago. There are so many styles, Oxford, Oscola. So there's so many citation styles. And in the upcoming classes, that is stages of legal research, I will be teaching you one or two most important, like Blue Book citation, or the most important citations. So let's not go into the style right now. One thing we should remember is you cannot give one Blue Book citation in the first page, and in the last page you cannot give APA citation. You cannot do that. So that are the things that you should remember. Next, what are you not supposed to do? You cannot reiterate. That is, you cannot just repeat what is a dissenting opinion. So in a given case, there'll be majority and minority. That is, majority, let's say there are 5 judges, and 3 judges have ruled. Let's take the example of Kunal Kamra. Let's say they have ruled that yes, Kunal Kamra is held for criminal contempt. Okay, so that is the majority. Now dissenting opinion is the minority. That is, Kunal Kamra is not guilty. He is not guilty for criminal contempt. He has not done anything wrong. So that is the dissenting opinion. Let's say in your case commentary, you are not agreeing to the judgment. That is, you are in favor of Kunal Kamra. You are also in favor of the dissenting opinion. So here, you usually, what people do is they just copy paste the dissenting opinion. They just copy paste verbatim, saying that I agree with this entire dissenting opinion. I agree that Kunal Kamra shouldn't be tried for criminal contempt. That's it. Just 1 or 2 sentences, and the entire thing they copy paste it. You are not supposed to do that. You have to give your own critical analysis, even of the dissenting opinion, like critical analysis or agreeing to it, whatever it is, should write it in your own words. Again, you are not supposed to paraphrase. Most of them, instead of copy pasting, they paraphrase. Turnitin, there's an app. Usually, whenever they go for plagiarism check, they use Turnitin, and in Turnitin check, it even tends to show the certain sentences that you've paraphrased. So that is also to be avoided. And you're not supposed to use jargons. Don't use typical terms that are already given in the judgment. Make it simpler. And you're not supposed to discuss any topic that is outside of the judgment. Now, given contempt of court, stick to contempt of court. Do not dwell more into Kunal Kamra's, let's say, something of his shows, the shows that he does on YouTube or whatever. You should stick to the case. You cannot go outside of the case. You cannot go outside of the judgment. And last is, you cannot, as I already mentioned, you cannot use excessive footnotes in case commentary. It should be very limited, max to max you can cite the case wherever you're using a particular case, and if you want to explain a particular term, you can use in 1 or 2 citations. You can, I mean, 1 or 2 footnotes you can give. Apart from that, you're not supposed to use excessive footnotes. One point that you should remember here is, usually law students, they tend to get confused between case commentary and IRAC method. So what an IRAC method is, it is basically the issues, rules, analysis, and conclusion. This method is used to solve any problem based question. If you are given a problem to solve, usually this happens in any assignment. They give us assignments, and that is, IRAC is the method used to solve a particular question at hand, particular problem, law problem. Okay, but in case of case commentaries, you're not solving a problem, it is already there. The case commentary, the case is already given, you are commenting upon the case, so you cannot stick to IRAC method. You have to follow the structure that we just discussed. So this is it, and these are the references that I used. So thank you. Any doubts, I'll take it.
uh,
Yeah, go ahead, Ashwin.
Yeah, so now when I'm doing this critical analysis, how much weightage should I give to the majority or the minority judgment? Like, for example, if I'm in favor of the dissenting opinion,
Yes.
and dissenting opinions generally are far ahead of their time, okay, when they give a judgment. So like, my basic question was, what sort of weightage I have to give,
Okay.
to my critical analysis?
Okay. So as we saw, critical analysis is the most important part, as in it covers 3/4 of your case commentary, if I may say. So here, if you are, it depends on you as a person. If you are in favor of the majority judgment, then definitely your weightage will be for the majority judgment. But if you are not okay with the judgment, let's say, I am a pro LGBTQ. I support the LGBTQ community. Okay, but there might be few people who are not in favor of it. So they will give weightage to the dissenting opinion, right? So it depends on you, which, which, like, majority findings are you in favor of it, or the dissenting opinion. Depending on that, you will start your case commentary. Even if I may say, you will start reading a particular case. You will know certain facts of a case from here and there. You will see in the news, you will hear from here and there, and then you would get interested, and then you will start reading a particular case. While reading it, you will get attracted to either the majority or the minority. Depending on that, you will start writing. So let's say, for instance, let's say you are interested in the dissenting opinion. Like, let's say someone else is interested in the dissenting opinion that is not in favor of LGBTQ community. In that case, you will just write, you will critically analyze the majority, that is, who all were in favor of the judgment, who all were in favor of the LGBTQ community, why did they approve it, why is it decriminalized. You will critically analyze that. You will say that no, this is not correct. The reasoning, you will give the legal backing, you will draft accordingly, and then you will come to the dissenting opinion and write in favor of it. You will say these are the reasons given by the dissenting opinion, right? You will not obviously copy paste, you will give your own sentences, and then you will further proceed with it. So to sum it up, to put it very simply, in simple terms, if you are in favor of the dissenting opinion, you will critically analyze the majority opinion, and you will in crux, support the dissenting one. Similarly, vice versa. If you are not okay with the dissenting opinion, you will critically analyze the dissenting opinion and go in favor of the majority findings. I hope this is clear.
Yes, thank you.
Any other questions? I hope this wasn't very legally tasking in the sense. I hope this was not very, how do I put it? I tried my level best to make it very simple and put it in very simple language, because it's very taxing in legal terminologies and all. It's very difficult to understand. So that's the reason I put it very in simple language, in very simple terms. So feel free to ask if you didn't understand any term, or if you found it to be very technical or very difficult to understand. I will repeat it again.
Ma'am, it was a really good and informative session. Please don't worry.
Ma'am, there are few queries in the chat box.
Okay, thank you. Whosoever said the session was good, thank you. And yes, I will go through the queries. Just a second. Okay, so the first one, Amit asked me, does it have three? Okay, okay. If I understood it correctly, I guess SEC, okay, SEC Online, the legal databases has no free access. Unfortunately, there's no free access. Usually, the law schools, they have a package, okay, and so we get all the legal databases freely under that. We have IP access, so we get free access through the college database, like they will provide us. But yeah, if you want to subscribe, it is actually costly. It varies from, per year, I guess it is around 27,000 or so, just for one SEC Online legal database. So usually what people do, they participate, like most of my friends who have passed out and they don't have access to SEC Online, what they do, they participate in conferences, or let's say some article writing or something of that sort. And usually the prizes that they award, in that you have access to SEC Online databases. So they try their luck over there. Yeah, so definitely access is not free. And okay, so the next one, facts of facts, how can they be viewed under plagiarism? Facts of the case will be same everywhere. Definitely facts of the case will be same everywhere. But that doesn't mean you can copy paste the facts, right? So if you, like we navigated through the entire case, right? So there certain terms will be used, like they'll frame a sentence in a particular way, in a particular format. All I'm saying is, don't copy paste that. Don't copy paste the facts. Write it in your own words. You just frame it in your own words. Don't copy paste. So any layman can easily figure it out, that that it is copy pasted from the judgment itself, depending on the terms. Like the terms that they use in a particular judgment are very different from that of the terms that we use normally on day-to-day basis. So yes, I hope I answered that. Next one is, how is a case commentary different from a legal article? Yes, okay, this is a good question. So yes, Harsha, a case commentary, as we saw, you are simply commenting on a case, right? You are analyzing the case, you are giving your comments on a particular case. Whereas in a legal article, you are writing an article on a topic itself. So if I may say, let's take the example of this again, contempt of court and Kunal Kamra case. Contempt of court will be my legal article, okay, and Kunal Kamra versus Union of India, just an example, like hypothetical one, that will be my case commentary. So this is the major difference between both of them. You will comment upon a case, that is case commentary. You will discuss an entire topic, that is legal article writing. I hope I answered that as well. Any other questions? Thank you, class. It was really wonderful teaching you. Thank you.
Do we have more questions from anyone?
No, I don't think so. We have any questions.
Thank you, Meenakshi, for taking out the time for today's lecture. I hope everyone has a better understanding about the writing now, because these will be used for your assignments too, for the at the end of the course, when you guys will be having your assignment submission and final exams. So I hope you guys have got it cleared now, and still if there is any doubt, you can reach out to me, and you can reach out to Miss Meenakshi via me. And thank you again, Meenakshi. Thank you, Arun sir. Thank you, Preeti ji. Thank you for taking out the times for all the lectures. It's really great of you, and it's like your support is really crucial for us. Thank you. Thank you, Gayatri, for today's session. Thank you, everyone. Bye bye, and a very happy Holi to you. Have fun. Stay safe. Thank you. Bye bye.
Happy Holi to everyone. Bye.
Thank you, ma'am.
Thank you, guys. Bye.